Hi, I'm Jill Headford, Head of Litigation at Tozers. I'm often consulted about covenants on land. Essentially, a covenant is a promise in a deed, usually not to do something on your land, but occasionally to do something. So typical examples would be not to build on the land, or not to operate a business there, or to erect and maintain a stock-proof fence along a boundary. No, not always. Assuming you own land which has the benefit of the covenant, there may still be an argument about whether you've left it too late to object to the breach. For example, if you've stood by and watched a neighbour build on their land in the face of a covenant not to do so, a court is unlikely to step in later and order them to knock it down, but you might still be awarded compensation for the breach. No. If a neighbour gets planning consent to build a house and you have the benefit of a covenant preventing it, their planning consent will not override your covenant. Well, a landowner with the benefit of a covenant might be prepared to release it, but will often want to charge a premium for that, and will almost certainly expect to have their legal fees paid. It's best to object promptly before your neighbour spends time and money, perhaps mistaking your silence for agreement. If you act before work starts, you have a fair chance of preventing it going ahead at all. And if you are the one contemplating disregard of a covenant on your land, you will wish to evaluate the risk before investing too much money. Whatever your covenant concerns, it's worth seeking professional advice from an expert. Feel free to get in touch.